Welcome back. You're watching Money, Money, Money. With me this week to discuss the possible ramifications of the amendments of the Maharashtra Rent Control Act are Ali Fazal Boy, Senior Partner at ALMT Legal, and Ashutosh Lamai, Head of Research and Real Estate Intelligence Services at JLL India. So we've discussed a lot about the good, bad and the ugly of these amendments. But I want to understand from you, Mr. Lamai, you spoke earlier about the condition of the buildings and how it could possibly lead to a lot more developers moving in. A lot of these buildings have already used up their FSI. So far, redevelopment has not happened because developers needed to buy blocks of buildings at a time. With rents being aligned to the market, a lot of people may end up moving out. Will this mean that a lot more redevelopment is likely in these areas?
I think yes. I think we need to again see building by building and units by units. So there will be buildings which have spacious units, and the families may not be as affluent as they were perhaps 60 years back when they actually moved into that spacious flat. So families occupying large areas but not that well-to-do may choose to go out, and developers would be happy buying out their properties even at a slight premium, and then that will make the redevelopment process that much simpler because the developers will have fewer people to deal with. But we have several buildings, highly dense pockets where the unit size or the apartment size is not that great. It could well fall below that 800 odd square foot threshold that is likely to get defined. They may not move out. So I think it will be those buildings who have spacious layouts, it might be easier.
But is there a danger that they may at some point also include flats below this 800 square foot?
Possible. Because right now we have no understanding of how that particular number has been arrived at. So once we understand the logic, that number can come down as well.
But Mr. Fazal Boy, I want to understand from you, a lot of, because the rent was so minuscule for so long, a lot of landlords may not have collected the rent. A lot of tenants may not have regularly been paying the rent and therefore may not have their rent receipts. A lot of landlords may not have been paying also property tax, or trying to show it as self-occupied to pay lesser tax. What is the legal position of tenants and landlords if this were the case?
See, I think tenants would be paying the rent because, as I said earlier, if you don't pay rent, even if it's 100 rupees, it's grounds for eviction. Of course, then you have to file a suit, and then the tenant can deposit the rent in court and you cannot be evicted. So they would be definitely tendering the rent, and all tenants would, everyone's savvy now, everyone's well versed with the law, and if the landlord doesn't accept it, they would record it in letters sent by registered post or whatever, I'm tendering the rent, or actually do a direct deposit into the landlord's bank account. So why would landlords not accept rent? Again, it's very difficult. Earlier the property tax was based on rateable value, means how much you could rent your property out for. So in fact, landlords would say, I'm only getting 200 rupees rent, so my property tax is low. If he's self-occupying, your property tax may actually be higher than if you're getting 200 rupees rent. So I don't think the earlier landlords would do that. Now the property tax has changed. They are now levying it on the capital value of the property and not the rateable value. So even if your rent is 200 rupees, your property tax may be higher because actual value of the property is more. There is some litigation on this which is pending, but that is the move, to change the levy of property tax, which has happened.
And this will be the death knell for the Pagri system altogether?
Not necessarily. Pagri was also legalized some time back. So now landlords are allowed to accept. Pagri is what? It's a premium, it's a fee that the landlord charges for allowing a tenant to transfer to another tenant, to a new tenant. So it's a fee that the landlord is charging. Now that was earlier illegal, so landlords used to take in cash. Now it is legal. It is recognized in the Rent Control Act, it is recognized in the income tax laws. So it is, landlords are taking a premium. Now what would happen is, suppose I have bought a Pagri place on Pagri 2 years ago. I paid, like, the market value is 1 crore, I paid at a discount 60 lakhs, landlord's taken 1/3, 20 lakhs. And suddenly my rents go up. I bought it thinking my rents are 200 rupees for lifetime. So how will I deal with it? Now that also has to be factored into the into the bill.
Taking this forward, a guy who's bought a property, say 1 or 2 years back, 5 years back, and he's paid this tidy sum as a pagri, as opposed to a family who's lived in that flat for 50, 60 years and therefore has been passed on. The flat may still be in the name of the original tenant. Would that sort of set the tenants back?
Not necessarily, because the tenancy is inheritable.
Okay.
So if it was in my grandfather's name when he passed away, my father or my mother, whoever was there, would be entitled to get the tenancy transferred. Now what a lot of landlords were doing is they were refusing to transfer it, thinking that then that will be a way to push them out. But legally the landlord is not correct. He can be compelled to transfer it, and the heirs can file a suit in the small causes court or whichever the appropriate court to have it transferred to their name, and that is their right.
All right, fair enough. So there's still a lot more questions that need to be asked, but before that, a quick break. When we come back, if you're one of the affected parties, whether you're a tenant or a landlord, what are the documents that you need to back you up? Stay tuned. We'll be back with all of that in just a bit.